Hi, and welcome back to another episode of What to Expect When You're Arrested. This is your host, Sean Hendrickson here from the Sean Hendrickson Law Firm, where we help good people like you avoid the devastating consequences of criminal charges. Today, we're going to talk about the two main advantages that the defense has in a criminal case. Before we get to that, I do have a free download for you. It's 5 things you should do right now if you've been arrested. If you click in the show notes, there's a link there and we can send that right out to you. We also have a link where you can schedule a free consultation. If you're being charged with a crime in the San Antonio area, I highly recommend that you schedule a consultation with us. We'd be happy to discuss your case with you, answer any questions that you have, let you know what to expect, and let you know how we may be able to help you out. Just click on the link for that in the show notes and you can schedule that without even having to give us a call. On a criminal case, the state generally has most of the advantages. The police are going to get information on the case. They're going to do their investigation. They're going to talk to people and make a decision about whether or not to arrest you. And if they do arrest you, it's because they should have enough evidence to move forward with this case. In a lot of situations, people aren't aware of their rights and they talk with officers sometimes when they shouldn't. Up until the point where somebody gets charged, the advantage is almost completely on the state side. And the reason for that really makes sense because you want the police to have the information to make a decision about whether or not to charge somebody in this situation. The defense does have 2 main advantages, though, in a criminal case. The first of those, I'm sure you've heard of, and that's the burden of proof. When you're being charged with a crime, you are presumed innocent. You're innocent until you're proven guilty. And what that means, as you all know, is that if this case were to go to trial, the state has to prove beyond a reasonable doubt that you committed whatever crime you're being charged with. And if they can't meet that burden, then the jury should come back with a verdict of not guilty and the defendant gets to walk away free and clear. So that is one of the main advantages that almost everybody knows about in a criminal case. The second is less well known, and I want to talk about it a little bit more because of how important it is. And that is that there's an information imbalance on a case. Up until somebody is charged with a crime, the state has more information on a case than the defense does. But once somebody is charged with a crime, that balance of information can change. Once somebody's charged with a crime, that balance of information can change. The state has to give me all of the information they have on a case. They've got to give me all the police reports, witness statements, 911 phone calls. Everything that they have to give to me. The only thing that they don't have to give to me is their own work product. So kind of their notes on the case and their case strategy. They don't have to give that to me. But in a lot of cases, I'm going to know what that is based off of the case anyway. I'm going to know what their best argument is that somebody is guilty. On the other hand, as a defense attorney in Texas, we don't have to turn anything over to the state. And that means that we can get information that they don't have. If the defendant didn't make a statement to the police, obviously I'm going to be able to get a statement from my client and I'm going to get their side of the story. And not just the side of the story, what they told the police if they did talk to the police, but they're going to be much more free with their information with me than they are with the police. In some situations, their police may not have reached out to all the witnesses, and I'm going to. And again, sometimes what those witnesses tell me is different from what they told the police if they did make a statement. The way that we're looking at every case is if this case goes to trial, what is that trial going to look like? What are the witnesses that the state's going to call? What evidence is there that they are going to try and bring in? And what can we do to kind of counteract that? Are there any witnesses that we can bring in? And is there any evidence that we can bring into the trial as well to show that the defendant is not guilty of whatever they're being charged with? We don't have to tell any of that to the state, which means that if a witness that they have is making statements that are inconsistent, then that's information that we're going to have that the state may not have. If there's a witness that wants the case dismissed and is not going to show up or is not available for some reason, we may know about that when the state may not know about that. We may know our client's side of the story, which is completely believable, and we know how our client is going to testify if they do decide to testify when the state's not. And so there's such a huge imbalance of information on at both sides. In the beginning, that's really one of the reasons why you don't want to talk with the police, is because they do have all the information. The officers out there, they may have gotten a phone call, somebody telling them that you committed a crime. Let's say that this is an assault case. They got a call saying that you assaulted some other person or you assaulted them. And they may say how you assaulted that person and when it happened and where it happened and all of that information. The police are going to come out and they're going to talk to that person and get that person's side of the story. And then they're going to come talk with you if you're the one being investigated. And the police are going to ask you what happened. There are two real reasons why you don't want to talk to the police at this point. First is that we don't want you making any admissions, saying, yes, I did it, I'm sorry, I didn't mean to, or whatever else. Obviously, that's not good information for your case. But secondly, everything that you say that lines up with what that other person said is just giving that other person more credibility. If 90% of y'all's story is the same and the only difference is that that person said you assaulted them and you said you didn't assault them, then the cop is probably going to believe that other person and move forward and arrest you. The other part that you may not be aware of is if you make statements to the police, there are other things that the state has to prove that you may be helping them prove. If you mention that you were there, they may be able to use that to identify you, that you were actually the person there at that time, and they can use your own statements against you in that situation. Whereas if you didn't talk with the police and didn't mention anything about that, then they may not be able to show that it was you there at that time. Maybe it was somebody else. And they're going to use all of those things against you. And so even if you go into a police statement thinking that as long as you explain things without, admitting to doing anything wrong, that you're okay, then that's probably not going to work out as well as you think it is, because there are a lot of things the police are looking at related to your statement where even if you don't make any direct admissions, they're still going to be able to use those statements against you. And that's why we don't want you talking with the police in the beginning, because in the beginning, they have all of the information that you probably don't have. You don't know what they know or what they think they know. That's why you need to reach out to an attorney, or even better, just exercise your right to remain silent. Tell the officer you're exercising that right and then don't answer any of their questions. After you're charged, though, that's when we get all the information that the officer thinks that they knew. That's when we get the officer's report. We can listen to the 911 call or the witness statement or watch the body cam to see what the actual accusation is against you and what that person said. And then once we have all of the information that the officer had, then we can make a better decision about how to move forward. Does it make sense for you to make a statement if this case does go to trial? Does it make sense for us to tell the prosecutor your side of the story in hopes that we're going to be able to get this case dismissed? Or is it better to just sit back, not say anything else, set it for trial, and then let all of this come out at trial without the prosecutor being able to prepare for that? I hope that this has been helpful for you. If you do have any questions, please feel free to give me a call at 210-405-6410. Or again, if you're being charged with a crime here in San Antonio, please give me a call there or use that link in the show notes to schedule a free consultation. I'd really like to discuss your case with you and let you know how we may be able to help you out. I hope you have a great day.